Good afternoon. My name is Joshua Houston. I'm General Counsel at Texas Impact, and we are here respectfully opposed to House Bill 3859. Texas Impact is a membership organization. Our member denominations have long been committed to the provision of child welfare services in the state. We've also been deeply involved in the creation of Texas's faith and community-based initiative over the last couple of decades. The struggles of our child welfare system have been on the hearts and minds of our membership. I've heard from Baptist in Tyler who want to know about reimbursement rates. I've heard from Methodist in Pasadena who want to know where the budgets are at this session. I've heard even from Muslims who expressed to me a desire to help because the Quran is just as clear as the Hebrew Bible and the New Testament about caring for the orphan. So we're here in opposition, but we have a desire to help. We've been visiting with the author, and we very much appreciate his championing of foster care issues this session. We agree wholeheartedly with the intent, the legislative intent, as it's expressed on the first page of the bill. However, the devil on these bills is in the details, as they say. There are provisions in the actual text of the bill that we fear open a Pandora's box of unintended consequences. One, we have concerns about the scope of the bill, that it's too broad. Two, we have concerns about creating ways to evade regulatory enforcement. And three, we have concerns that protecting the provider is overriding the religious liberty of other parties involved in these very complicated family law cases. Those particulars are provided in our written testimony, but I do want to use one as an example that has to do with the physical disciplining of children, which can be a sincerely held religious belief for some groups. Back in the 1970s, there were faith-based ministries that argued that licensing of children's homes violated their religious freedom. Our member denominations strongly supported the Child Care Licensing Act back in 1975 because of a minister named Lester Roloff in the People's Baptist Church. He claimed that the Child Care Licensing Act didn't apply to him because of religious freedom. After two interim studies by the legislature, 12 years of litigation, the state finally shut him down in 1985. But some of you may remember that name because Roloff Evangelistic Enterprises reopened in 1997. The legislature has twice dealt with Lester Roloff because the legislature didn't get the balance exactly right between religiously motivated conduct and protecting that and protecting the health and safety of children. We need to be 100% certain that the health and safety of children prevails, and that's why the language is so important in these bills. We have three principles that we think, if applied, strike this balance. We have handed out written testimony, and I'm referring to stuff that we have written on page 34. But those three principles are this, that first, government must not prefer or disadvantage one faith relative to another, and that includes no faith at all. Two, government must not force any person to act against their conscience unless there's a state interest that compels it. And three, government must not permit adherents of one faith to harm non-adherents as an expression of faith. The provision of child welfare is very fact-specific. We think a bill negotiation with all the stakeholders is necessary to fully understand the implications of the language. If this were a bill about electric utilities or copper recycling, that's what we would do. The Texas RFRA, which we passed in '99 in this very committee, very good example of this process I'm referring to. We would urge this committee to follow the same process of having all the stakeholders negotiate the language out and not pass a bill until at least all the faith groups of all the faiths in Texas get to neutral on the bill. We appreciate your work, and we look forward to working with you.
Okay, members, any questions? Yes, Reverend Rodriguez.
Briefly, thank you for being here and testify. Do you see any on the language that on page 4 that talks about, the sincerely held religious beliefs, any, for lack of a better word, like limitation on that other than, I guess, the best interest of the child? Is that the standard? I mean,
I've not seen a committee sub. I'm not seeing where the best interest of the child would prevail. And with regard to discrimination, I'd refer to page 6. These are some of the things that are trying to exempt out. So some of the limitations, like on page 6, you've got the area about not discriminating based on race, ethnicity, or national origin, but it doesn't say religion, which is part of the Civil Rights Act. You could presumably have a provider discriminate against somebody of a different faith. Okay. With regard to law enforcement, right above it says that law enforcement duties aren't inhibited, but that requires probable cause. We also have concerns that maybe DFPS couldn't get in certain situations. We want to make sure that that's not hindered. Part of the advantage of licensing is you don't require probable cause; you just get right in.
So, what you're talking about on page 6, if you added religion or if you added sexual orientation, could that solve some of this? Or
It's hard to say. It's hard to say what all the different providers' concerns are because faith is so diverse in Texas, and we think the only way to really be able to figure out how to create that balance, like we did with Texas RFRA, where 50 different faith groups all agreed it was a good bill, is to get them all in a room and just really hammer out it's very fact specific in these cases. There's so many different competing interests between children and parents and biological parents, foster parents, different providers, secondary providers, the state, and taxpayers. It's just a very complicated thing.
Thank you. Appreciate it.
Thank you.